Right, 5 minutes to the top of the hour. Karibu sana. This is Morning Cafe. I'm used to Stanley Nyoringita. It is time for legal matters. With us is Silas Akiro. He's an advocate of the High Court. Good morning, Silas.
Good morning to you, Stanley. How are you?
Mimi niko salama. I think I should be telling you happy 12th anniversary of people who walk along the corridors of the Apex Court.
Oh, thank you very much.
Yes. Ladies and gentlemen, this particular morning we discussed something that really touches on so many people. There are so many people who are married, actually who are planning to marry, who are married, or who have been divorced. And the biggest conversation is always property. And we'll be analyzing what property means, because the first thing that people think about when we mention property is land. But Akiro will be helping us understand that. And the meat of this conversation takes us back to 27th of January 2023, when the Supreme Court ruled that marital property must be shared on the basis of fairness and not in accordance with an automatic fixed formula that imposes a whole 50-50 kind of a split. So this is the opportunity to call in live 0795 045 864. Ukitupigia simu, tell us your name, where you're calling us from, and kindly have your TV off. You can also text us on WhatsApp 0793 267 279. I'll be sampling all of your feedback. Our question of the day for you is, what are your thoughts on the whole idea of spouses having and garnering property separately? What are your thoughts on that as well? Akiro, help us understand from the basis of this conversation. First of all, what is matrimonial property?
Matrimonial property, from the word matrimony, it simply means the property acquired by and between the husband and wife, which forms what you could call, this is a family property. What in simple terms people prefer to call family property. So basically that type of property acquired between a husband and wife during the existence of their marriage, that forms part of a matrimonial property, in simpler words. Yes.
Right. So the law clearly, when you take a look at the Matrimonial Property Act, help us understand what this act means in a nutshell. It breaks down if a spouse can actually own property separately. Can he or she do that? And at the end of the day, will there be any challenges arising?
Well, the law as it is does not interfere with any person's individual rights. There are those rights that can really not be taken away from any individual citizen, including those who are in marriage. For instance, owning individual and separate property, that has not been taken away from you either by the Constitution or by the Marriage Act or the Matrimonial Property Act, or any law in the country. And so it is very, very possible, Mr. Stanley, that two people living together can have different and distinct assets before, during, and after the subsistence of their marriage. However, for cohesion, in the society that we've grown, it is always pertinent or important that the two build a family together. Because as soon as this disjointed ownership comes up, then the family begins to grow suspicion and could really disgruntle and set apart. But some people have been able to. For instance, a funny moment, just for the sake of conversation, Stanley, that I once encountered is a man and a woman who got married, and then they built a very big house. And so they would share the kitchen, but live in different bedrooms, and also still share the living room. However, their lives were separate. The man could not get into the woman's room, and the woman could not get into the man's room. Living two people under one roof, but living separately And it's like, Coco, are you done? I would want to fry my eggs. It's my turn. So you see such kind of lifestyle that made the constitution not to close it for individuals in a marriage to own individual property.
All right.
Yes.
And the law, the matrimonial, actually, the Constitution, Article 45, Cap 3, talks about states that spouses have equal rights at the time of marriage, during the marriage, and at the time of dissolution. I was hoping for you to talk about even, before marriage, they're not really spouses. But then I'd love us to now start on that point, because it seems that that is a genesis of all this conversation. Before, let's have a hypothetical. We have a John and Jane. So John and Jane decide that we're going to get married. They're not yet legally married. And we have so many Johns and Janes watching us this morning, Wakili. And they really want to understand, before we get married, how can we escape all this kind of hurdles that, I mean, I genuinely want to just have my own property, or we'd want to jointly have property. How can they walk through this whole path, legally speaking, Wakili?
As it has been said before, marriage is a contract. And whatever you do is by agreement. And most of the property acquisitions during marriage can easily be transformed into contractual agreements. And so, in some jurisdictions, the laws of those lands have come up with what we call the prenup, what some people call the prenuptial agreements. And this would dictate how, before you enter into this marriage, you are going to operate together as a unit in terms of responsibilities, in terms of property acquisition, in terms of property ownership, in terms of growth and development of your house or your family or your marriage. Now, when you come back home to the Constitution of Kenya 2010, particularly the article you have mentioned on equality, before, during, and after marriage. Now, equality before marriage here would mean, you remember, in our society, even now as we speak, if you're going to get married, then the huger responsibility is put on the man. Pre-marriage, responsibility is heavier on man's shoulder. Get dowry, get the dress for the lady, get the wedding banquet costs, put them yourself. So literally, you are taking the woman, so she comes as she is. There is nothing she is supposed to contribute.
Depending on different cultures.
Yes. But now the Constitution comes here to say that responsibility here is equal. And so, whereas you could say that, yes, the man should show his ability to be able to maintain and take care of his wife during this pre-marriage period, by bringing dowry and what have you. But it is equally important that during the wedding consolidation of resources, the Constitution envisions that the contribution from both parties should be a 50-50.
Okay.
In that, in a better proportion, if the man has struggled much to take dowry, the woman would really look into this thing significantly and take care of the wedding arrangements. So that is what the Constitution envisions in terms of a 50-50 pre-marriage arrangement. Now, during marriage arrangement, now here we are talking about acquisition of property. And there have been different schools of thoughts, to the extent that on 27th January, when the Supreme Court of Kenya gave a decision, it looked like a whole mountain dropped on the country as a landmark decision. However, the Supreme Court's decision was actually within the law, and it was nothing out of the blues. the biggest difficult, the most difficult decision to make in terms of 50-50 arrangements within marriage is when one spouse has the ability, maybe financial muscle, maybe academic muscle, but the other spouse is disadvantaged. Mm-hmm. In our society, mostly it is the women who are always disadvantaged.
So on a hypothetical, remember you still have John and Jane here.
Yes.
And you've mentioned something that so many Kenyans right now are really trying to embrace. They're having these conversations
sure.
More widely. It has been tainted to be a Western culture, kind of the prenuptial agreement. So how does it, if I was coming to you as Wakili, and so the couple is then, they're saying, we want you to draft this agreement for us. So first off, how does it look like? What kind of details should be in this prenup agreement? What kind of documents do I need to come with when I'm visiting you?
Well, it is important that during your prenup, you disclose all that you have, mm-hmm. and then you express your intentions to your advocate so that the advocate may be at a position to put down your intentions together. Now, for instance, a prenup agreement is no different from normal agreements. It is simply you people agreeing that when we get there, for instance, all assets, whether acquired by you or me, will be in our joint names. Or when we get there, each party will acquire his or her own assets in his or her own name, and the other party will not claim any interests,
okay,
whether or not they directly contribute. Or would simply say that when we get there, despite us having different property rights and interests and acquisition, if the other participates in the development of the other person's property, then he'll be entitled to some benefits as though he was working for the other. Mm-hmm. You see? So it depends on how you voice out what you want to do during your nuptials. Because prenuptials is simply an arrangement. You're preparing a ground on how you're going to exist in your nuptials. And so for those who have assets, they can bring them and they be listed in the agreement.
Okay.
And remember, when we were talking about contracts, we have an issue of capacity. These are prenuptial. First of all, is your marriage viable? Because there are those prohibited degrees of marriage. Mm-hmm. They are outlawed. Mm-hmm. So when we are talking about now construction of a prenuptial agreement, we have to look at the circumstances. This is an agreement into marriage. So what can void this marriage? Prenup. What can void it is whether the agreement was entered as by and between persons of good capacity, 18 years and above. Mm-hmm. Whether or not they were entered into as by and between parties within the degree of marriageable bracket.
Right.
For instance, in our country, you cannot marry your cousins unless you are a Muslim. That is the only exception. Mm-hmm. So you cannot do a prenup with your cousin if you're not a Muslim. That will be a voidable prenuptial because the marriage itself is voidable. Number two, if you have your assets, then you list them that while or before we came together, this and this and this and this were my property. Mm-hmm. And so that is a good point, an advantage of a prenup. Because instead of you working to hide your assets from your spouse every now and again, fearing that your spouse may find out and turn against you all of a sudden and maybe finish you in a bid to take those assets. So you can have a way of locking them up through this prenup agreement.
So you'd advise our hypothetical here, John and Jane, to have this prenup.
Exactly.
But then is it revoked? Is it one revoked? Is it, can you edit it later on during the marriage?
Yes, yes. Every agreement can be amended so long as the makers of the agreement are still existing
Okay.
and the amendment is by mutual consent.
Right.
Parties can agree that let us agree to amend the rules of the game at this clause or section. Remember? However, the courts will have it a little bit difficult whether to term the new agreement post-amendment as a prenup, whether the prenup would be used retroactively upon amendment.
In layman's term, what does that mean?
I mean, it could be used. You could take it from as though it was made before we came into the marriage.
Okay. Okay.
Because remember, the amendment creates a new, or sort of a new contract.
Okay.
Yes, and so if you are calling it a prenup, yet you are making the amendments during the nuptials, then the court will be questioning. Of course, the opposing counsels would, the biggest question they would want to know is whether the amendment falls under the brackets of a prenup.
Okay.
However, for wise advocates and counsels, they can set the ground rules for an amendment. And the ground rule would be that the parties are at liberty to amend this agreement mutually by agreement.
Okay.
And any amendment made thereafter shall be construed to have been an amendment made before the nuptials.
Okay.
So with that clause, then you're already making any amendment, even post-divorce, to be used as though it was made before the nuptials.
Right. So hypothetically, there's a couple that is watching us this morning, and they're wondering, they got married 1 week ago, 2 weeks ago. They did not have this prenup. They maybe they didn't hear about the prenup before the marriage, or they heard about it, but then they did not take it with that ile energy inafai kuwe with what you're telling us right now. And they're wondering, so what if one of maybe the man or the woman wanted to own property separately in the course of the marriage, and they do not have this prenup? What happens?
Yes, remember, a prenup is a precaution. But the theme of our constitution and our laws, as I espoused before, is not to deny any individual the right to own property separate from the other.
Okay.
So with or without the prenup, the wife or the husband still has the constitutional right, the legal right to own his own asset. But remember, the moment the other spouse makes a contribution to this individually owned asset, then whereas the other spouse would have it difficult to show contribution, this spouse will be entitled to a share based on his contribution on the asset individually owned. So it means it was Jane and James, eh?
John and Jane.
Yes.
Jane,
yeah, John and Jane. So it means if John bought a car, and then while John was driving it, the car gets an accident, and as John is in the hospital, the car has no insurance, or the insurance has expired, and then Jane takes the car to the mechanic. Jane has already contributed to John's privately owned car. And so, at dissolution, Jane will be entitled to a share of John's car.
What if John paid back? the money that was used.
So John will now inform the court that, yes, whereas I acknowledge she's entitled to a portion or a share, I did refund. So if those refunds receipts are available or can be confirmed, then the court will acknowledge that there was a share of this magnitude and the share has already been recovered. So the matter is settled. The matter of Jane's share of John's car has been settled.
All right. I'm taking a look at the Matrimonial Property Act of 2013 and what it continues to talk about, the acquisition of interest in property by contribution. So it also alludes to the fact that if you just stayed together, non-monetary contribution, because in our case here, you tell us about the monetary contribution to this privately owned car. But then the Property Act also tells us, even for the benefit of the viewer, so that they understand that just being with you, Jane and John being together, that also is a contribution to itself, non-monetary otherwise.
Yes, Stanley, you know, ability to make wealth requires several constants. Number one is an ample and quiet environment. You see, if there is political instability in a country, the country's economy is doomed. And so if this woman has given you this ample time to be able to regenerate and make wealth, that can be a quantifiable contribution, a significant contribution to your family. And so these ones, we normally call them indirect contributions, and assessments are always by the court. And so that is what I think that was the Bosibori case that we're looking at here, which originally came from the High Court, petition from the High Court. We saw one ladder of our good juries awarding a 30%, while the other overturning it and saying, no, it's a 50-50%. And finally, the Supreme Court saying, yes, we agree it is a 50-50%, however, show us your contribution. So, not a 50-50% on every asset that Jane has or every asset that John has. It is a 50-50% of the assets that you have contributed to together. So these assessments will just be made by the courts in terms of indirect contributions. However, to be able to achieve that limit of a 50-50 contribution, then it is best calculated if the contributions can be quantified by yourselves. That is direct contributions. In direct contributions, it is left for the courts to assess what amount or what is the significance of my indirect contribution to your overall wealth acquisition or creation.
So that would mean for, let's say, if it's Jane in this case, and the lawyers before court, it would really be difficult for them to actually prove this is my indirect contribution. For example, companionship. Because do you think they'll be clutching at straws here, trying to prove this is, I was your companion and I really contributed to that extent?
Yeah. You know, the extent of or the significance of your companionship into my overall wealth acquisition and growth can still be questioned. The mere fact that I have a ring, you have a ring, and we are in the house doesn't mean that you are giving me a peaceful environment. Probably if I can get one or two neighbors who've constantly met us exchanging blows, if not blows, but words. And so there is no peace. Every time I leave the house gloomy, that means I am basically regenerating myself on a daily basis. You're not giving me that environment for me to replicate myself, you see? So in this, I will counter your lawyers or your advocates' request for indirect contribution, right? And in fact, on another way, this is now my thought on stage, though it hasn't been put on measurement, is not in, not seen it in any legal decisions. In fact, if your companionship has really led to much negativity in terms of drawing me down, then I can easily, or rather, I can argue it in court that but for her or but for his negative companionship, I would have reached this level. And so I can urge the court to provide, or rather to give me or to award me the margin. But then when it comes to quantification of someone's indirect contribution, that is not an easy task. And that is why you see the difference in decisions from the three levels of courts. While one of them got it wholly wrong,
from the High Court to the Court of...
to the Supreme Court.
To the Court of...
All of them have different decisions. However, in my view, as I told you earlier, the Supreme Court and the Court of Appeal are in agreement.
Okay. Before we take a look at some of the comments here,
Yes.
because so far, and for the benefit of the viewer again to understand, we'll take a look at the Matrimonial Property Act that clearly stipulates all this, the separation of property in spouses, as well as the Constitution now, Article 45, Cap 1, as well as Cap 3. Which one has more weight? Which one really gains weight before this courts and then the justice system, really?
Between
the Matrimonial Property Act and Article 45(1) and generally the Constitution.
You see, when you look at Section 159, 2, all the way down, any law that is inconsistent with the Constitution is no law in the Republic of Kenya. And any law permissible by the Constitution but has some provisions that are inconsistent with the Constitution, those provisions are illegal. So what do I mean? When you look at the hierarchy of laws in Kenya, the Constitution towers high. So the significance here, in fact, you will always get an act of parliament to be unconstitutional, but you can never get the Constitution being illegal based on an act of parliament.
Okay.
You see? So the Constitution becomes the breather of all laws we have in the country.
Right.
So the primary law here is Article 45 of the Constitution of Kenya.
Right.
And Article 45(4) now gives life to the matrimonial property because it says Parliament shall enact. So without Article 145(4), then the matrimonial property, if it doesn't have any lifeline within the Constitution, is supposed to be thrown out. But now, if for the purposes of your question, it is Article 45 of the Constitution of Kenya 1 first, then the provisions of the Matrimonial Property Act.
Right.
Yes.
Viewer, Article 45(1) says that the family is the foundation of social order and is a natural and fundamental unit of society. It also states that the state should recognize and protect the family. For Article 45(3) says that spouses have equal rights at the time of marriage, during marriage, and at the time of dissolution. So with all this, even as you also prepare to call us live, 0795 045 864. For calling live, tell us your name, where you're calling us from, Uzime Sauti TV. And then for WhatsApp, 0793 267 279. The number of messages from you guys, I'll be sampling them and asking Wakili. On Facebook, Sam G here says, our question of the day, do you support the idea of spouses acquiring property separately in a marriage? Do you support the idea of spouses acquiring property separately in a marriage? So Samji here says, never shall this happen. Marriage is a joint union made with a purpose to pull together. When such opinions find way on couples, then marriage is not in existence. Kiplangat Tuwei says, not bad if done in good faith, but from my own humble opinion, it's a very, very dangerous trend. This has led to a lot of marriages breakage and misunderstanding. So Wakili, when you sample some of this from Sam as well as from Kiplangat, they talk about marriage as an institution and the core that it really holds. And it reminds me of what the Supreme Court was saying last year. And just to quote it, as Constitution looks forward and backward, vertically and horizontally, as it seeks to re-engineer the social order. When you analyze what the Supreme Court is telling us here, and take a look at also the marriage as an institution, what it was 10 years ago is not what it is now, and it is not what it is going to be 20 years from now. The generations change as well. So in front of the courts, how should they rule some of these matters as times change?
The Supreme Court already gave the precedence.
Kidogo tu, before you continue, we do have Caro from Machakos. Caro, habari asubuhi?
Nzuri.
Habari watu wa Machakos?
Nzuri kwa sawa kabisa.
Uko na swali kwa wakili wetu ama ni maoni?
Kwa wakili.
Yes, uko na swali? Uliza tafadhali.
Nzuri.
Caro, kabla uendelee, zima sauti ya TV tafadhali. Caro umepotea toka Machakos. Keep on calling us 0795045864. The moment umeshika simu ukatupigia, kindly have remote zero volume ndio tuongee na vizuri. So yes, back to this conversation. Just to reiterate it again, times are changing in how we view marriage as an institution, and when it comes with the acquisition of property as well. Are the courts also moving with this, or are they in the backward ways of how things should be in marriages?
Stanley, as you have quoted properly from the court, and I believe the Supreme Court was answering the petitioner's question, that this petition was filed before the promulgation of the 2010 Constitution, and so ought not to be adjudged from a constitution that came at a futuristic stage. And so the Constitution, the Supreme Court stated that for a constitution, it operates vertically, horizontally, future and past.
Yeah.
So it is right to apply the Constitution of Kenya 2010 for a 1990 incident. That is what the Supreme Court was indicating in that kind of. However, when it comes to now an act of parliament, it would be difficult to quantify whether to use the act that was there then or the one that is existing as at now. And so when you look at the major reasons why most people, including your commenters, if you follow them up carefully, you realize that if they are married, they have certain assets they have hidden from their spouses. The reason being, you people have heard some of this very strange and sad and unfortunate news. We have an estate of 700 million US dollars, for instance. And your wife is there looking at you, and she knows that the only thing that is coming between her and owning the entire estate for herself is your existence. Then what do we get? Somebody's wife has murdered him, or somebody's husband has murdered the wife. Reason being, alikuwa anataka mali. He wanted the wealth. And so you find that for the sake or the lesson some Kenyans have learned from these few incidences, one of them was rumored. I would like to put a disclaimer though. One of them was rumored to be the Tob Cohen case, the owner of the Philips.
Could I kindly interrupt you in that train of thought? We do have Leonard kutoka ni Bungoma, Busia. Yes, Leonard, habari asubuhi.
Salama.
I hope watu wa Busia mko salama.
Tuko salama, tunashukuru.
Uko na swali kwa wakili ama ni maoni kuhusiana na masuala yetu ya property ya spouses?
Nina maoni pia na swali. Kwa maoni.
Okay, naomba upaze sauti kidogo.
Okay, kwa maoni. Naweza sema kwamba kidogo sheria zetu ni nzuri, lakini zingine pia inatukandamiza kama raia. Because ukiweza kuweka marriage kwa njia hiyo, ya kwamba mtu anapokuwa pale kwenye ndoa, anaweza acquire properties nje, ambayo sio nzuri, because that one makes that marriage being casual. Because ni kama mtu ako pale tu mguu moja nje, mguu moja ndani. So that one makes that marriage a bit technical and haiwezi dumu.
Okay.
Yeah. So swali kwa wakili ni kwamba mambo ile ya tamaduni hiyo kwa sheria itupiliwa kabisa, because I think hiyo na zingine wa cultures also zinasaidia kwa mambo ya hizi marriages.
Okay.
So wanawezaje kuweka hiyo mambo ya culture kwa mambo ya sheria yetu kama constitution yetu ya Kenya?
All right.
Asante.
So thank you very much Leonard. Salimia sana watu wa Busia.
Yes.
Waambie endelea kutazama TV47.
Asante. Naipenda.
So thank you very much. Wakili.
Yeah, Busia is a very good place. Actually, I was there a few days ago. It's good to encounter a caller from Busia.
Yes, and he raises some very pertinent questions. And his thought of train is what we were discussing before his call.
Yes,
There's a law, yes, but then does the law really favor what people want? You can talk about that, but then also answering his question, the role of courts, the role of the law here, actually the role of culture in interpreting these matters.
Yeah, you see, the Constitution, as I said, is the parent law. It is a parent statute of the Republic of Kenya. Every other law, rules, regulations are subject to the Constitution. And so if you look at Article 159(2)(c) of the Constitution of Kenya 2010, it allows customary laws, but so long as they are not inconsistent with the Constitution. So any customary rules or guidelines or laws that are within the confines of the Constitution are welcome. For instance, if there is a marital issue and the elders can easily sort out this issue without going to court, the Constitution applauds that. It welcomes that with all arms. If there are certain rules governing marriage that are working for a given community, but which are not inconsistent with the Constitution, those are welcome. So your culture, your societal or community or clan norms that are not inconsistent with the provisions of the Constitution are welcome. You can practice them. It is very much allowed. In fact, so much that you can do your marriage in your culture, then simply petition the registrar to give you a marriage certificate. You are not bound by the Western or civil system or type of marriage. So you can just do it, celebrate it, solemnize it. Just make sure that if you are marrying according to the Kamba customs, ensure that you fulfill all the Kamba customs.
Okay.
If you do not fulfill all the Kamba customs of marriage, then that marriage would be voidable.
Okay.
So to Enoch, the Teso,
Leonard.
it's called Leonard, yes.
Yeah.
Yes, the Teso, the Samia, or the Manyala type of laws or rules are allowed and welcomed by our constitution.
So does this mean that you're going to be having the Council of Elders, because he's calling from Busia, the Council of Elders from these communities that you're mentioning, before the courts to interpret what and how property was shared among this couple and even the children and the generation all together?
Exactly. So during a question on the marriage, be it divorce or matrimonial proceedings, an expert from the community will have to be called.
Okay.
And an expert doesn't mean somebody with a PhD in this context. An expert here would even mean a mother who does not even know how to spell her name, but is well versed with the community set rules and principles. How was marriage conducted? So in fact, they will be explaining to the court step by step, from here to here, from here to here. Then the court will view, of course, a countering expert may be brought in.
Okay.
A countering expert may be brought in by the other side. So if their expertise opinion is different, then the court can enter into its own research.
Now, on that bit of research, the Matrimonial Property Act, the number 8 of it talks about property rights in polygamous marriages. So it talks about if parties in a polygamous marriage divorce or a polygamous marriage is otherwise dissolved, the matrimonial property acquired by the man and the first wife shall be retained equally by the man and the first wife only. If the property was acquired before the man married another wife, and the section follows says matrimonial property acquired by the man after the man marries another wife shall be regarded as owned by the man and the wives, taking into account any contributions made.
You remember what I
by the
told
man
you,
and
Stanley?
each of the wives.
You remember what I told you? That the Court of Appeal and the Supreme Court are on the same page, albeit differently. The Court of Appeal considers the 50-50 as equal on the face of it.
Okay.
But the Court of Appeal considers it is a 50-50 based on your contribution. And what that section indicates is what I had already informed you.
Let's pick Carol's call from Machakos Amirudi. Carol, habari asubuhi tena. I hope umezima sauti ya TV sasa.
Nimezima.
Good. Uko na swali au ni maoni?
Ni swali nauliza lawyer.
Yes.
Can the law,
okay,
if you want to divorce somebody, can the law now deny you that? Can it force you to be together if you don't want to be together?
Can the law deny you not to?
Can you be, now you're in court, can you be forced by the law to be together if you don't want to be together?
Okay. Wakili, umepata swali?
Yes.
Yes, sawa. Thank you for that question.
Then I have another question.
Okay.
If you have deserted your matrimonium for more than 7 years, can that be enough for divorce?
Okay.
Yeah. Those are my two questions.
So thank you for those questions, Carol.
Let me answer her before we come to the interesting bit that we were discussing. Courts have always held that marriage is an agreement between two parties, and two parties can never proceed in a marriage unless they agree. So at that time, when the disagreement comes in, then the marriage is considered irretrievably broken down. As such, there is no law that forces Jane and James to be together by force. However, to protect the sanctity of marriage in Kenya, there are rules that have to be followed. For instance, you have to fulfill the reasons for marriage, for divorce, which include irretrievable breakdown of the marriage. It includes cruelty. It includes desertion. You've been left for a span of more than 3 years. It includes irreconcilable differences. So those ones, if you are just deciding for me and this house, it is done, you can't petition immediately.
Okay.
If you do, you have high chances of not getting the divorce.
Right.
And the courts have discretion to do so. And remember, there is no divorce by consent in the Republic of Kenya. Ati, umeamua hivyo, o sawa, tuende. No, you'll have to inform the court and give proper reasons why you're divorcing.
Right. Caro kutoka Machakos, I hope umepata jibu hiyo. In case you're just joining us right now, Wakili was answering.
Actually, to add on, Stanley, the reason or the rationale behind that is that there are people acquiring citizenship. Remember, if you are married to a Kenyan and you are a foreigner, you are entitled to Kenyan citizenship. So somebody just comes and hooks up with Njeri from Muranga, and within 1 week, they are up because citizenship is done. Or some business that was being done in the country, and the only way this person would come to do his shoddy deals is through this sham marriage. So then the courts disagree on the basis of divorce by consent. That is not allowed in the Republic of Kenya. There is no divorce by consent. In fact, Parliament tried it the other day. They put up a bill to allow parties to divorce by consent. If they have agreed to disagree, then let it be so. That's what they were arguing. But the bill was shot down. I think it got some serious opposition. No, Parliament is really unique. They can come up with their own bill and they shoot it down.
They shoot it down themselves.
By themselves.
Right.
Yes.
So before Carol's call from Machakos, we were discussing it was at Leonard's call from Busia. And
Carol asked about 10 years.
Yes. And you've said at least 3 years.
Yes, exactly.
Yes, so you've answered that.
Yes.
So Leonard's question about the role of culture in solving these matters of property or for spouses, be it. And in such matters, because now you're explaining to us how we can have an expert on matters culture in front of the courts. And there might be some disagreement, and the courts and the judges will now have to do their own research. And I was reading this whole bit of the property rights now in polygamous marriages. So I brought up polygamous marriages because they are very frequent in now matters culture.
Exactly.
So how do courts...
and that is what I was saying. That is what I was saying in answering you on the question of Section 8 of the Matrimonial Property Act. Is that I began by saying that both the Supreme Court and the Court of Appeal were on the same page, albeit different.
Yes.
They are all reading from the Constitution of Kenya, particularly Article 45 on equality. So when you look at the chronology there in the Matrimonial Property Act, the law states that in a polygamous marriage, and assuming the marriage took place sequentially, I didn't meet a group of 10 women and married them off at once. We remember we've seen such kind of scenarios. But assuming the marriage took place sequentially, the law states that my property acquired individually before I contract any marriage, that is mine. Then any property I acquire between me and the first wife, before the second wife comes in, we share this, then any property I acquire between me and the second wife, that one shall be shared between me and the second wife alone.
Not the third wife. No.
Not the third wife.
Okay.
And the sequence goes on like that. That is the implication of that section.
Okay.
That is what I was telling you, that the Supreme Court was not taking the 50-50 on the face of it. Mm-hmm. It interpreted it in terms of evidentiary proof.
So basically saying that the 50-50 is not cast in stone. Mm-mm. Okay.
It is a 50-50 contribution or share, but prove it. So in here, the woman, the first wife, has to prove contribution with the husband. The second wife, the same. The third wife, the same. And you see, what the law is guarding against here is that all of them claiming 50% of a man's share. So assuming he has 1 million, 10 wives.
Yes, so how does that go again, the division of the contribution?
Yes, he has 1 million, he has 10 wives. So all of them cannot say, kila mtu anapewa 500,000.
Yeah.
You see? And assuming between him and the first wife, the contribution is 50-50 on the face of it, then he remains with 500,000. Then the other wife will say, I am entitled to 250,000 of the 500,000. And you see, at the end of it, the man remains empty. So the law now leaves it for these individuals to do what? To prove.
Okay.
So you're only given a share of what you have contributed.
Right.
If you've not contributed it, I'm afraid what the Supreme Court indicates is that you're going to go zero, or with the assessed indirect contribution only.
What about inherited property? How do the courts interpret this?
Yeah, you see, an inherited property, from the woman's side, remember, we are still struggling with this bit of jurisprudence in our country, because it has given women a lot of property rights, because the woman can inherit from the father's side and still gets the right from the husband's side.
Yeah.
Husband's side. So then, whatever has been inherited, the property rights is transferred to the next generation. So from your father, the property comes to you. So that is your property, right? If this woman comes in and contributes to that inherited property that belongs to you, the woman has contributory rights to that inherited property. Be rest assured that at your demise, I pray for long life for you, of course. I would always want to come for more shows. Assuming at your demise, the woman will have whole life assurance over your property, meaning she owns it as long as she lives.
Wow, okay.
So it's a whole life assurance over your property, and subject to her remarrying. If she remarries, the whole life assurance goes.
Right.
It's shifted to somewhere else.
Right.
And so, of course, that is another law altogether. We are now looking at succession there.
Yes.
But now, in terms of matrimonial property here, if there is any property from your parent that has come to you, and you have the property rights over that property from your parent, that belongs to you. And whatever contribution she's made in that, then she's only entitled to 50% of what she has contributed, what she has contributed.
Right. Ladies and gentlemen, we have about 8 minutes to wrap up. So this is some amazing time to make sure that you call in live or to me a text so that Wakili can answer your questions on having property separately as a spouse. You're married, but then you decide, I just want to have my own property that either my wife or my husband does not know about, or rather knows about, but then asinisumbue uko mbele. There are a couple of questions here for you. So one, Kiruka says, what about retirement benefits? Assuming I get married at 56 years, can it also be on prenup?
Yeah, whatever property you want to put on your prenup, you are allowed. You can indicate there that I'm a retired man. This amount of money is coming to me every month.
Okay.
So that is not part of what she has contributed to.
All right.
Yeah.
Let's pick this call from Kisumu Dala. Jeff, habari asubuhi?
Salama sana.
Watu wa Kisumu mko chonjo kabisa.
Tuko chonjo.
Uko na swali for wakili ama ni maoni?
Niko na swali.
Yes, uliza.
Ningependa kuuliza, in a case where somebody gets married,
Okay.
and then you participate in buying a property yourself, but put it in your spouse's name. But then along the line, you disagree. And then the other spouse claims that since you put the property on her name, then the property now belongs to her or him. Yeah. Is it, what chances do you have to claim the property that you can claim that you personally just put up?
Right.
Thank you. Number one.
Yeah.
Continue, yeah.
All right. Number one, it has been considered by courts that a title deed, for instance, is not an absolute proof of ownership. Explain to the courts how you acquired that title. So, if the agreement for sale is there, and the agreement for sale indicates John is buying this land, but he is going to put it in the name of the wife. You see, the ownership here and the terms of the agreement will override the person whose name is in the title. However, if he was only sending money, but sending the money directly to the owner, the agreement and the seller and the details of the buyer are all the wife. You know, it will be difficult for him to prove that the money he was sending was for the sale of this, for purchase of this land. And so what he can do is simply contribute and develop the land. So at dissolution, while the woman will be going with the assets, he will claim contribution.
Contributions, yeah. Both monetary as well as non-monetary.
And non-monetary.
Yes.
However, it is important to educate us as individuals. Love is a beautiful thing, but love has also cost us lives. And like I was giving the example, the moment I know that my wife, who is an MP, has put all his life saving on me, I look for a way of getting rid of my wife. Because the only stumbling block between me and owning the whole asset myself, controlling. You know, the issue here is not owning, it's controlling. Because controlling now, that is power.
Okay.
Is my wife. And that's what we have always seen. People have murdered themselves left, right, and center. And that is why, although initially no man would hide the number of cows he has from the wife, when money came into the world, no man would hide how much he was earning. In fact, I grew up in a setup where my dad and my mom, they knew the bank account number and PIN. That is how they lived together. But we are looking at a society where matrimonial property is causing more and more deaths. And that is why you see a lot of women and men are running away from joint ownership of matrimonial property. And that really requires each and every person who would want to lavish the other spouse with assets, and you are not giving them off completely. It is something you want to own later, meaning you're putting it to her in trust for you or your family later. Visit an advocate and share that with him. He'll help you in coming up with the best idea on how to do this trust agreement.
Right.
Otherwise, anything properly in your wife or spouse's name really belongs to her.
Right. So even as we start to wrap up, there's also a question here that I believe really touches so many people. We always have this street slang of baby mamas and such like. So this person asks, if the man has a child outside marriage, can that child's mom get the share of the property?
No. Absolutely no. Unless the child's mom was married
Okay.
to
The person.
the person.
Right.
And marriage here is whether customary or Christian. But remember, if her customary marriage came after the Christian or civil marriage, then that customary marriage is null and void. Remember, Christian marriage is a marriage of just but one man, one woman, to the exclusion of all others. The same to civil. However, the law allows that if you have 10 wives married customarily before, and then later you come to marry one through Christian or civil, then your customary marriage and the Christian marriage will be accepted, but you'll be precluded from contracting any other further Christian or civil marriage afterwards. You get that?
Right.
So before, yes, they are allowed to be your wives. After the civil or Christian, you are not allowed to take up a customary marriage. But remember, in most Christian marriages, they will not allow you to marry on top of customary marriages. They don't allow you to have polygamy. So this is just within the interpretation of the law.
Okay.
But the practice out there, the moment your pastor will get to know that you have 10 of them and you want to add one of them here, nobody will preside over that marriage.
Right. Very briefly, because again, as we have discussed the kind of callers we've had, this really goes to show, first of all, it's an issue that affects every part of this country. And speaking of callers, we do have, is it? Okay. Okay, so in a minute, what will you say about this matter? What should Kenyans know about this matter if they are thinking about owning property separately as a spouse?
The biggest thing is, what we need to know is that it's very dangerous because it has no cohesive force to unite your marriage. The moment your spouse will know that there are certain things you are hiding from her, the marriage will begin to shake and ultimately split out. Number two, it is not illegal. The law allows you to own property separately. Number three, at dissolution of the marriage, parties are only entitled to what they have contributed. 50% yes, but 50% on what is contributed.
All right.
And then lastly, what I would say, build trust, build love, and cautiously. We have seen many of our leaders sometimes, they've been telling us, do not kill yourself. Yeah, do not die. At least life is important.
Most definitely.
When you see it is getting dangerous, try to find a way of ironing out issues.
Right.
But don't cling to something that is too dangerous for you.
Thank you very much, Silas Akiro, he's an advocate of the High Court. Thank you very much for every single person who has called in live, who has texted us on WhatsApp as well as 22047. This conversation continues because we'll be making sure that you understand some of this legal implications that they have on your society. I'm truly Stanley Nyeringita. Have yourself a blissful day. We continue with a very special coverage of USA Decides 2024. Don't go too far. Tukio will be coming up in an hour's time.
Great.